yes, you were looking at Ridgeway.
We were, and indeed I finished with Ridgeway.
Right.
So the only part of my submission that's left is just to deal with some responsive points to some areas touched on by the learned friend. I think I can be quite brief. The first is just the point about the facts.
Point about?
The facts.
Facts, yeah.
So it may be helpful to have to hand core bundle page 101. There was, I think during an exchange with my Lord Justice Lewison, where my learned friend suggested that this wasn't a case where you could actually live there. There were no utilities at all. You may remember that. My learned friend pointed to para 19, which said all the kitchen units and appliances had been damaged and none of the utilities worked. I mean, no criticism of my learned friend, because neither of us, in fact, appeared in the first tier tribunal. But I think reading in context, that's only referring to the kitchen. If one looks to the next paragraph, it says every room was a mess. Water, gas and electricity were not functioning safely. And then if one goes on to the various works which the tribunal said need to be completed, which shows at para 32, does talk about the property requiring a complete rewiring. That's the first point in sub C1.
Sorry, where are you? 32, yes.
Yeah, para 32, sub C1.
Yep.
One can see that it's not talking about replacing all the things relating to the utilities. My reading is that the utilities were functioning, just not sufficiently safely. It's just a point of detail. But that list of items in para 32 are worth dwelling on, because the learned friend wants to argue that uninhabitability is a high hurdle, but the list of repairs here, each of which the FTT seems to think a reasonable person would want fixed before moving in, are unexceptional, and they are not structural. They are commonplace. And so this also feeds into my concern that I made before about wanting a robust distinction between residential and non-residential property. It would be odd if a property was residential without a boiler, and then once the boiler's fitted, it becomes residential, or non-residential with leaking pipes and no longer non-residential once those pipes are fixed. And the finding which my learned friend has in that regard is that para 34, it's actually the part that's just over the page on 104. It says, in any event, I do not consider that any reasonable, sensible person would be prepared to occupy a house with potentially dangerous electrics, gas and water and a kitchen in that state. And that's important because when we talk about uninhabitability, we're usually talking about whether something could be lived in, whereas here the first tier tribunal is talking about something that a reasonable person would be prepared to live in. So there may be some difference there, and I just pointed out because I think when my learned friend talks about uninhabitability, he's not using it in the same sense in which we saw in the consultation paper and so on. So much for the facts. The next area I just wanted to cover was the landlord and tenant cases. I've already made my central point on this, which is that those are concerned with different context. And actually the Aldford House case is quite a good example, if I may, because the legislation there was framed in terms of something that was constructed or adapted. It's clear that the legislation is focused on the current state and not what use it might be put to in the future. Third theme, my learned friend criticised the upper tribunal for referring to fundamental characteristics of the property. And in essence, we say what the upper tribunal has done is a straightforward, common sense approach of standing back and looking at the building and saying what uses is this suited to, even if not ready for. But the challenge which my learned friend made was that I think, what are these characteristics, and how can these all be how can these be all the characteristics of a dwelling? Otherwise, it would be suitable for use, as in ready to move into. Now, there are 2 points to make about this. The first is that this is actually quite a good example of a property that has the fundamental characteristics of a dwelling, albeit it wasn't ready to move into. So take the utilities. It's connected to the utilities. My reading of the first tier tribunal decision is that they were indeed functioning, they just weren't functioning safely. It's obvious, it seems to us, that a house configured as a dwelling on a residential street may well have all the fundamental characteristics of a dwelling, even if it's in a state of disrepair such that a reasonable purchaser wouldn't be willing to move straight into it. Now there can be, I think the second point is, there can be no real criticism of the upper tribunal here for not identifying what are all the fundamental characteristics.
Well, I think Mr. First's point was that unless you know what the fundamental characteristics of a dwelling are, you can't say of any particular property whether it has them or it doesn't have them. You've got to identify them before you can reach a view.
And so the criticism would be that that wasn't done here.
Well, it isn't. I mean, I think Mr. First's criticism is it's not done at all in any of the tribunal cases, or indeed in your Skeleton argument, that his point is that HMRC, while adopting this test of fundamental characteristics, has not identified what they are.
It may be helpful just to see how the case has been argued below, just to explain why it's ended up like this. So in the first tier tribunal, again, I emphasise that the learned friend didn't appear there. Paras 35 to 38 set out what the taxpayer's argument was. And in effect, the argument...
35 to...
35 to 38
of...
the first tier's decision.
Yes, I beg your pardon, thank you.
No problem. So, in effect, there it says taxpayer accepts relatively minor disrepair, not sufficient. But their case is that the property was suffering from much more than minor disrepair, and goes on to explain that the taxpayer's case was, in effect, it was too dangerous to live in. So it isn't a case where the taxpayer is saying that it lacks a kitchen or a bathroom or whatever, or lacks utilities. It's a case where the taxpayer is arguing that the state of the characteristics are such that somebody wouldn't want to live.
Well, you may be right on the facts of this particular case, but I think Mr. Firth's point is a broader one. He says, as I understand it, the statutory word is suitable. The upper tribunal have interpreted that as meaning lacking the fundamental characteristics of a dwelling. But unless you know what the fundamental characteristics of a dwelling are, you can't apply that test in any particular case. And therefore, you are thrown back on a different meaning of the word suitable, because the test that HMRC have adopted is one that is simply a subjective test on any given set of particular facts.
Too vague, yeah.
I mean, that's I probably haven't put it as well as he did, but that's the idea as I understand it.
I understand. I suppose my first answer is that there are some cases out there, some of which have drawn on, for example, the Eurotemps case, you see in the House of Lords decision on dwelling there. It's simply that this wasn't the case to explore that. That's really my answer.
Right.
But is it so difficult anyway? You start with a building, it's got to be a building, not a flat area of ground or a river or a tree, it's got to be a building. what are the characteristics, I don't think fundamental adds anything, of that type of building. It's not a building that's used for office workers, office education, it's something else. What? A dwelling. And you just work out what, in the current time, would be the features of a dwelling. 60 years ago, in the village where I grew up, most houses didn't have bathrooms or toilets indoors. Had no bathroom or toilets outdoors. Now that's changed. You'd expect there to be bedrooms, a living area, a kitchen, bathrooms, and connection to utilities, possibly these days, even connection to the internet. So there would be a range of things that you'd expect the building to have if it was to be suitable for use as a dwelling. Whether they're in good repair is another question, but it's not as difficult, perhaps, as has been suggested.
Indeed, and I don't think that there's any dispute that this was a building configured as a dwelling, it is a house, and that it had formerly been used as a dwelling. It is just the state of disrepair, and that's why I say we don't get into the fundamental characteristics. It's got them, it's just that some of the characteristics need replacing.
All right.
I think I'm on my fourth theme. This time it's the meaning of adaptation. You already have my point that one needs to read the phrase as a whole. So it's adaptation for use as a dwelling.
Well, adaptation of a building, isn't it?
Yes, indeed. Adaptation
For use
of a
as a
building for
dwelling.
use as a dwelling. My learned friend suggested that the case law indicated that adaptation means, or perhaps can mean, made suitable only. And I think this is based on Day and Hosebay, but we weren't taken to it. Perhaps it's worth just looking it up, because I think it's not good authority for the point. It's tab 13 of the Authorities Manual, page 229. The first thing to note perhaps is just the legislation on page 234, so that one can see what the court was dealing with.
Yeah, it's the leasehold before that case.
Yeah. So whether something is a house, any building designed or adapted for living in and reasonably so called. And then at para 31.
Well, just before we get there,
Yes.
what Lord Conway says at 9, he's looking at the first limb of the definition. Looks to the identity or function of the building based on its physical characteristics. Now, identity is of some importance, and it comes back when he refers to what Lord Denning said about the Ashbridge Investments case and whether something has lost its identity, and that's a theme that's taken up in the Aldford case as well.
I'm grateful. So it may be that my Lord already has my point on this. I was going to highlight at para 31 the quote from the House of Lords case and just check it to see if it's
31.
Yeah, in fact, 30 and 31 refers to a House of Lords case. I think it's Boss Holdings, Groves and West Properties. Can I just invite you to read the pull-out bit that's quoted, in my judgment, words designed or adapted for living in that bit?
This is from Boss, isn't it?
I believe it is, yes. Lord Neumann.
Yeah. Yeah. Well, yes, I mean, I think that what Lord Conway says at 20 and 21 is of some importance as well. Again, we see this idea of change of identity, lost its identity.
Yes. And in the pull-out quote that I was drawing attention to, again, it's about has it been adapted for another purpose? If so, what purpose? It talks about there could have been successive adaptations, only the most recent of which is relevant. So it's clearly dealing with something that had a design, and then the design, in effect, changes through the adaptation. Now, the bit that my learned friend, I think, relies on, or at least in my learned friend's skeleton case, is further down. It's para 35. But I think that paragraph needs to be read as a whole, and in the context of the judgment. Can I just invite you to read the whole of 35?
Again, we're coming back to the present identity or function of a building.
Yeah.
And in 35, when he talks about physical character, whether derived from its original design or from subsequent adaptation, you need to read that in the context of 34, where he says context and common sense argue against the definition on historic design if that has been superseded by adaptation to some other use.
Agreed, my lord. And so I think the bit about adaptation just means made suitable. I think that's focusing on the question of whether there needs to be any structural work. Because, of course, the facts in Day and Hosbley were about large townhouses which had been converted into flatlets. It may be that there was no structural work involved in some of that. But had they been adapted, well, I understand the point being made is they could have been, even if there was no structural work to do that. It's not saying that any form of repairs which makes something suitable for use is an adaptation.
No. And we come back at 36 to this idea of losing identity.
Yes.
He says he doesn't question the decision in Boss. The basis is the upper floors which have been designed or last adapted for residential purposes, not been put to any other use, had not lost their identity as such, i.e. as residential, because they were just used and dilapidated.
So that's all I had to say about adaptation. But just to pick up now, it's my fifth point, on an example of something which is in the process of construction. Because my learned friend had an example, and I think the core submission was that if two buildings need the same type of work, they shouldn't be treated differently for SDLT purposes. But the legislation just isn't arranged in the way that my learned friend would like, and I can make that good, I think, in uncontroversial terms. My learned friend's example was a building which has been partly completed, let's say mostly completed, but not now in the process of construction. And the comparison was drawn, well, what about a building that's in essentially the same state, requiring the same sort of works, but those are repair works rather than construction works. My learned friend said it would be odd if the building not in the process of construction were treated as non-residential, but the building in need of repair was treated as residential. But that distinction really revolves around the words "in the process of," because it's obvious that two buildings, one of which is in the process of construction and one which is not in the process of construction, might be treated differently, because in the process of is the gateway to that limb of the residential property definition.
Now, it is a slightly odd place to draw the line. I mean, take the example of a developer who wants to build a housing estate, and he takes a conveyance or transfer of a partially completed housing estate where there is an ongoing process, and so he pays SLDT on the basis that it's residential. He goes bust. The construction comes to a halt, and the administrator or liquidator is now selling a half-completed housing estate where nothing is actually happening to somebody who's going to take on this work and complete the estate, but hasn't started yet. So it does change at that point, doesn't it, from residential to non-residential for no obvious reason.
I mean, it must be. It's not. It's obviously not our case, and
No, I follow. But I mean,
about
if one's looking at this, trying to make sense of this definition as a whole, there are anomalies.
There are, and all I say that there's a difficulty in me stating what in the process of means. So one could imagine that if tools were down for a short period of time, one might say it's still in the process of. But perhaps if it were for a longer period of time, a tribunal might say that it wasn't.
Yeah, well, I mean, take an intervening insolvency, and the insolvency practitioner is appointed to do what best he can with his half-completed building site.
Indeed. I guess I'm suggesting that that sort of anomaly is one that ought to arise rarely in practice, whereas the anomaly which my learned friend's reading of the legislation creates, a property in disrepair falls outside of the definition of residential property, whereas a property which is in the process of being constructed, perhaps as we suggested only a wall that has been built, is residential property. That anomaly is a common one. So that was my fifth point, my learned friend's new build example. The sixth point is, I think my last one, unless I can help my lords further, is about abuse. And again, I think I can deal with this quite briefly. We agree with my lord that Rossendale is unlikely to be the answer to a question of fact. One needs to take a realistic view of the facts, and that can't here mean ignoring features of the property itself. At best, that would be an untested extension to the Rossendale principle. Another point just to note here is, because the difference in rates is such between residential and non-residential property now, a vendor might be incentivized without consulting with the purchaser to make a property uninhabitable, if it can be done in an easy way, such as pulling out all the toilets. And if that were so, the purchaser may not know what were the vendor's motives for doing it. But the purchaser's the one that's liable for SDLT, so it'd be slightly odd to use an anti-avoidance provision against the purchaser when something has been done by the vendor.
Sounds like a rather unlikely scenario. Why should the vendor who's selling property make it uninhabitable in order to benefit the purchaser? Unless he gets an increase in the price, in which case the purchaser would presumably know that the price is being increased because of the potential SLDT saving. I mean, otherwise it seems bizarre as an example.
If my learned friend is right that the properties in this sort of disrepair are non-residential, then they become a more attractive proposition because the difference in SDLT rates is such. So
I've got a house, very nice house. I'm going to sell it for £2 million, and I reckon if I take out all the toilets and make it uninhabitable, I might get 2.3 for it because of the change in SLDT rates the purchaser is going to pay. That's the sort of scenario you're envisaging.
That's the sort of scenario I'm envisaging. De minimis rule. My learned friend pointed to the de minimis rule as another way of dealing with the problem that people might try to make properties uninhabitable in order to benefit from the lower rates. But the difficulty with this rule seems to me to be one of principle for my learned friend, because the de minimis rule is just another attempt to give effect to Parliament's intention. And we say, my learned friend is right to say that Parliament didn't intend that minor repairs to properties would prevent them from being residential. Even if that's something a reasonable purchaser would like fixed before moving in. That is HMRC's case. And once you accept that Parliament didn't create a hard line test based on current habitability, it undermines the points which my learned friend makes about a straightforward application. In effect, my learned friend is just drawing a different line in the sand. In any event, I have to confess, I'm not sure I understood how the de minimis test would help my learned friend. So if one were to remove a circuit breaker from the electrics, those electrics might become unsafe. It may be a very easy thing to fix. Equally, if one removes a window, it's the sort of thing that somebody would want fixed before moving in. But on what basis does one say that those are de minimis problems? They're the very sorts of problems that this property had, where the electrics weren't working safely and it had broken windows. So it seems to me that the de minimis principle, which Malone wants to introduce, proves too much for his case. That was all I had to say about abuse. Those are my submissions, unless I can help you further.
Thank you very much. Mr. Firth, do you wish to reply?
I'll be brief, my lord. My first point is that the dispute is not about whether it's a multifactorial test or not. The dispute is about what the test is. Many tests are multifactorial, but in order to know what the factors are, what we should take into account, you need to know what the test is. So to say it's a multifactorial test doesn't, in my submission, advance matters.
Yeah.
Second, Ridgway case says that legal restrictions on use are relevant as well as physical restrictions. I wouldn't disagree with that. But it does raise the interesting point as to whether, on HMRC's case, or the upper tribunal's decision, we have to consider how fundamental the restriction, the legal restriction on use is. Do we have to get into considerations of, well, how easy and through what process might we lift that restriction? That seems to be the logical consequence of adopting some sort of test based on fundamentality. If we could look, please, in terms. So, third point is the FTT case law. My submission is it's limited, and it's of limited relevance. If we could pick up the upper tribunal decision at 24, please, just to quickly run through those cases. So the Bewley case at 24.
Just hold on there. Upper tribunal at 24.
Yes, my lord. So this is where the upper tribunal goes through the existing FTT cases. In the Bewley case, it couldn't be used as a dwelling and couldn't be made suitable. It had to be demolished, so it didn't raise the sort of issue we're looking at.
Mm-hmm.
Fianda at 25. The problems were not ones that would stop you living there. Or at least there's no finding that they would stop you living there. 26, Fish Homes, was applying a test of whether you could live there. And you can see that at the end of 63, a reasonable person would
Well,
not
in fact,
say...
somebody was living there. Miss Fish was living there. Under an informal arrangement with her parents.
Yes. Well, and
So it was actually being used as a dwelling, despite the
I'd have to
dangerous
really
cladding.
check the facts to check that point, because that would make it irrelevant whether it's suitable for use. But you can see that the test being looked at in 62, 63, 64 is whether a person would live there, and you can see at the end of 63.
I'm not sure that's right. 64, what Judge Hellier said, I think it was Judge Hellier, I found the risk imposed by the cladding was not such as to prevent the flat from being a dwelling. Miss Fish was actually living there.
Yes, and at the end of the previous paragraph says a reasonable person would not say it was too dangerous to live there. So conversely, if a reasonable person would say it was too dangerous to live there.
Well, I'm not sure that follows, because she was living there.
Yes, but my point is it doesn't assist us. was a suggestion there's a consistent line of FTT authority leading to the upper tribunal decision in our case. My submission is actually no, they're dealing with discrete issues, and the reasoning is different and addressed obviously in this case to a different point. So that's the extent of my submission here, is to say that, well, the case law is limited and doesn't really address our point. Henderson, which is the closest, was decided on the basis of following our decision in the FTT. And so really that's the extent of it. We have the Henderson decision following our FTT decision. And then we have a few other cases in my submission that don't advance it.
Right.
The fourth point is, please, on the meaning of residential property. So my learned friend made a submission that, well, we can get some assistance from the just general understanding of what residential property means. Could I take you back very briefly to the Packard case, just to emphasise one point? Tab 28 in your authorities. I'm not going to give you a page number because I think I've got different page numbers. Tab 28, please. That might even not be tab 28, I apologise.
No, it's
No.
Is it 27 by any chance?
Yes, it is.
I think I got the row decision twice. Could I ask you to turn, please, to paragraph 49?
27, I've got it. Tab 27.
Yes, paragraph 49, please, my lord.
49.
Yes. And
Yes.
just by G, you can see, just above G, where an express definition of a term is given in a statute, then even if there is consensus as to its core content, in the absence of a general consensus as to the limits of the term, no significant potency can be attached to the term so as to colour or qualify the meaning of the definition. In my submission, that is our situation. There are lots of things that everyone would agree is residential property, because it wouldn't matter what test you applied, everyone would agree that's residential property. But we are precisely in an area where it does matter what test you're applying, and that a different test may give a different result.
Yeah.
Quintville, in my submission, it doesn't support HMRC. Suitability there was used to narrow rather than broaden the category of what was suitable. Page 205, please.
Can you give me a tab number?
I'm hoping it's tab 11.
11.
oh, 11, yeah.
Para 11, page 205, please. You can see the test under consideration at the end of that paragraph. Practices designed to secure that embryos are in a suitable condition to be placed in women, or to determine whether the embryos are suitable for that purpose. And the point is that the narrower the category of what is suitable, the broader, the more practices you can carry out to determine whether it is suitable. On the facts of the case, the argument was that in order for this particular embryo to be suitable for this particular mother, it had to have a tissue compatibility with her existing child. And that was important to this mother because she wanted some treatments. And so the question is whether that could factor into the suitability question. And the answer was that, well, it can. And so you can see what's happening here is that the suitability of the embryos for this mother is narrower than simply embryos that can be placed in a woman and will grow into a viable child, because this woman has additional requirements. And therefore, what's being done is narrowing the concept.
Well, it was actually expanding it, in fact.
Well,
it wasn't just things that were suitable for women. Here, she wanted the baby to be able to be a bone marrow donor for her older son.
It's narrow. Yes, it's narrowing so that you start off with a class of embryos. All of them are viable, but only certain of them would be a tissue match. You're narrowing the category of what's suitable from everything.
I think it's worse. What they were arguing about, because oddly enough I was in that case, but what they were arguing about was whether or not you could allow, treat as part of suitability, the preferences of the parent. In that case, the preference for bone marrow match with the older child.
Yes. And so you're using the additional considerations to narrow the category of what's suitable, but nobody was saying that something that couldn't be implanted into the mother would be a suitable embryo. I mean, the trial judge held that, well, as long as it's viable, that's enough. And then it was narrowed in the House of Lords based on the concept of suitability taking into account the subjective desires of that particular mother. But that doesn't assist HMRC because everyone was agreeing, well, it has to be something that you could use for that particular purpose. The question was, well, can we go further and say, well, this particular mother has particular desires that mean that that's not suitable? Answer, that can be taken into account as part of the suitability test.
I don't think it helps at all because it's suitability in a very specific context.
Yes.
Whether the regulatory authority could allow choices by a parent to indicate what was a suitable treatment.
But my point
It wasn't
is
just
that
a clinical thing, it was not clinical for the mother or the fetus, but clinical for the other baby that they already had.
Yes,
that had the disease.
Through the mother's own desires as to what she wanted for a particular embryo in her case. And the point I'm making is nobody was saying anything about, well, it doesn't have to be actually something you could use for the purpose of implanting in a woman. The question is, well, given that you can implant into a woman, can we narrow the question of suitability further? And the equivalent of that sort of reasoning in our case would be to say, well, given that there are people who could live here, a reasonable group that could live here, but this taxpayer says, well, it's not suitable for my purposes, can I rely on that to say it's not suitable for this dwelling? Obviously not, in the context of our case. But the point I'm making is that when the House of Lords talks about it being an empty vessel, they're talking about narrowing the concept of suitability, not expanding it beyond that usual meaning. Sixth point, my other friend referred to a building in the process of construction and suggested that in my case it stops being residential, I think at the point the external works are complete, and then becomes residential again when the internal works are completed. In my submission, that's not what I was saying. The whole process is one of construction, including the internal works. Seventh point is to briefly deal with the examples my little friend gave. And my overall submission is that in most cases it's based on aligning something that is easily capable of being made suitable for use with saying it is already suitable for that use. And so the two clearest examples of that would be a knife requiring sharpening, easily capable of being made suitable. In fact, you probably still can use a blunt knife. You don't need a sharp knife for all purposes. So my submission, that doesn't assist HMRC. Looked at in contrast, if you opened a package and it would take months of work and significant expense to become suitable or capable of being used as a knife, then you would have been misled. On the flat tire example, I mean, again, this is about aligning easily capable of being made suitable with actually already being suitable for use. If you can't drive it, it's not suitable for use. And to consider another example, imagine you have and this is more closer to our situation, a vehicle where all the electrics have been stripped out or broken, the doors are broken, the windows are broken, the roof's leaking water, and the radiator is being removed or is hanging off. And you were told, well, this is suitable for driving. And you clearly say, well, no, it's not. And that shows that, I think in my submission, what my learned friend is doing is taking something very close to being suitable for use and saying, well, that slight change doesn't change the category, but that's just based on aligning easily capable and made suitable for use with actually being suitable. In relation to the construction of a school example, well, in my submission, construction work includes preparing the site and therefore includes the demolition, but I don't think it's useful for us to get into a new debate about what construction means. Snow chalet, you're snowed in, well, plainly could be used as a dwelling, and that's what the people inside who've been snowed inside would be doing. So my submission, none of those examples illustrate my friend's point, and it means he hasn't got any example of his particular usage. Eighth point, I don't have much to say on this, but Hansard, it doesn't help. It's not clear and unequivocal. It shouldn't be looked at. Ninth point, consultation document. Well, we've seen it. It says the implicit distinction is between habitable or not. 10th point is my two identical building example. The point I was trying to make and illustrate there is that the historical reason why the works are required should not make a difference. So in a situation where you've got two buildings and they require work for different reasons, the reason why it requires work, given that there's no process, that we're not involved in that, given it's not actually used, so we're only looking at suitability for use, the reason the works are required shouldn't make a difference. And that's the point. We're not looking at the first limb, we're not looking at the third limb, we're just looking at the suitable for use limb in the middle. In my learner friend's case, you would have a different answer based on the same limb for building that requires work because it was never finished constructing, not residential, compared to one that requires the same work and is in the same physical condition because things were taken out or stripped out for some other purpose. So it's applying the same limb to two identical buildings and getting two different results based on the historical reason why the work's required. In my submission, there's no justification for that. 11th point, de minimis rule. The point of the de minimis rule, it doesn't affect the statutory test you're considering. It didn't affect the demolish to the ground test in the VAT context. It doesn't affect the test here. All it does is that it says that the law doesn't pay attention to things that are de minimis or lack real substance. And that's a well-established principle. Parliaments generally presume to legislate on the basis that principle applies, unless there is reason to think it doesn't apply, and then you go through a process. And my learner friend still hasn't given you any reason to think it doesn't apply. Therefore, you should conclude it would apply. And then we end up in the final submission and reply, which is, well, what is the alternative test? And I'm still standing here very puzzled as to what the test is on HMRC's case, because at various points we were told, well, it's suitable for use even if it requires some work, which raises the question of what some work means. Then we seem to go back to the fundamental characteristics test with no explanation of what those fundamental characteristics are. My lord sort of to run through, well, this is what you'd need for a dwelling. Talking about things like toilets and kitchens and connections to mains. I mean, if we're saying that each of those is a fundamental characteristic of a dwelling, then it will logically follow in a case where you don't have that, say the toilets have been removed, say the kitchen has been removed, say it has been disconnected from the mains, that on the test adopted by the upper tribunal, supported by HMRC, would have to say that it's not residential on the suitable for use test. But in my submission, that can't be and isn't what the upper tribunal is saying, because it seems to draw a distinction between characteristics of a dwelling and fundamental characteristics, because clearly you can have characteristics like that which are lacking, but the upper tribunal would say that's not sufficient. And that seems to be our case, because we do lack fundamental characteristics in terms of utilities and similar.
What about the language of identity? It's almost like the question I asked at the beginning. What is this building now? It certainly was a dwelling. It now is in need of repair, but has it lost its identity?
Well, the identity test makes sense when you're looking at a test of was it constructed or adapted for use. You're looking at what's happened in the past, the identity given to it through its construction or adaptation, and saying has it changed. That's not our test. Our test, as I said earlier this morning, is consistently looking at use. Is it being used? Is it suitable for use? Or is it being constructed for that particular use? And so an identity test, which Parliament could have adopted,
isn't capable of satisfying the suitable for use as a dwelling. Yes,
it's just a different. As I said this morning, there are so many different ways you can try and express a distinction between residential and non-residential. The identity test, looking at what it was designed for, looking at what it was constructed for, last used for, adapted for, all would involve potentially looking at an identity type analysis. But here we've got a use analysis, a very clear and consistent use analysis through each level of section 16. And so that's why I get back to where I started, that you've got a very simple concept, used or suitable for use. And my submission is, well, it has the same temporal focus. At that time, is it actually being used, or could it be used for that particular purpose? If so, the test is met. And well, I don't think I can put it any more ways. I still do not know what the test is on the other side. We're told about fundamental characteristics, but we're not told what they are, and it may end up being all the characteristics. I mean, there was reference to Euratemps, but if all the Euratemps conditions are fundamental characteristics, then then again, we need to go through and see whether they are met or not met in this case. Unless I can be of any further assistance, my lords, that's the submission and reply.
Thank you very much. Well, thank you both very much for your very economical submissions. It will not surprise you to learn that we will reserve our judgments. You will get a draft in the usual way. The draft comes with a strict embargo, which means exactly what it says. It will be your opportunity to correct our English, but not our reasoning, and not to introduce new arguments. We would hope that in the light of the draft you will be able to agree a formal order disposing of the appeal. If you can't agree a formal order, please make short written submissions and we will make the order that we consider to be appropriate. The eventual hand down of the judgment will take place electronically by release to the parties and the National Archives, so there will be no need for any further attendance. Thank you very much.